Excellent. I now welcome representatives from the University of Western Australia by video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to parliamentary committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
Robert Shenton French, Chancellor, University of Western Australia.
Amit Chakma, Vice-Chancellor at the University of Western Australia.
Thank you very much. I'll now invite you to make an opening statement and then we'll open up for discussions.
All right, well, perhaps let me begin. I thank the committee for the invitation to appear before it at this important inquiry. We meet at a time and surrounded by events which I would not have imagined possible in Australia. But even in this morning's Western Australian, they have newspaper, they have counted, I think, some 116 incidents of anti-Semitic events around the city. My comments will be relevant to the terms of reference concerning university frameworks, and particularly focus upon the application of the Model Code on Freedom of Speech and Academic Freedom, which has been adopted by, in one form or another, by many universities since my report on the topic in 2019, and the adoption of the code by the University Chancellors' Council. It's been substantially adopted by UWA under the title UWA Code for the Protection of Freedom of Speech and Academic Freedom. The Vice-Chancellor will deal with any more specific issues that may arise in relation to the terms of reference generally. No doubt that the committee is already familiar with the general lineaments of the Model Code. Importantly, it does not itself contain a code of conduct. It sets out the kind of limits that can properly be placed on freedom of speech and academic freedom in university. Before considering the limits on freedom of speech and academic freedom, it's necessary to consider what is not within the scope of freedom of speech. If some expressive activity does not get to first base as part of the freedom, the question of limits on the freedom doesn't arise. Now, that proposition covers the issue, for example, of encampments and the occupation of university offices. University lands are lands set aside for particular purposes, and in the case of UWA, governed by a set of bylaws. There is no right to come onto the university lands and set up a tent or any other form of encampment. So it's not a question of a freedom which can be constrained, it's a question of a freedom which doesn't exist to begin with. So one doesn't have to view the encampment issue through the prism of whether it's anti-Semitic or otherwise. Where the question of freedom of speech or academic freedom is engaged, the permitted limits under the code are reflected in Part 6. And so that part of the code, reflected in the UWA code, says that every member of staff and every student at the university enjoys freedom of speech exercised on university land or in connection with the university, subject only to certain restraints or burdens. Now, the first of those are restraints or burdens imposed by law. And that, of course, picks up the law that applies to everybody, which would include provisions such as Section 18, capital C of the Racial Discrimination Act of 1975, the racial vilification provision. Secondly, the reasonable and proportionate regulation of conduct necessary to the discharge of the university's teaching and research activities. So, for example, conduct which disrupts a teaching activity would be legitimately constrained under the university's code of conduct or behaviour codes, which the Vice-Chancellor may speak to separately. Then there's the right and freedom of others to express themselves. You can't interfere with that, and the university's right to make rules about that. Importantly, the freedom is also constrained by the reasonable and proportionate regulation of conduct to enable the university to fulfil its duty to foster the well-being of students and staff. Now, that duty itself derives from the higher education standards and the government standard in Domain 6 of the Texas standards. I think you'll be hearing from TEXA shortly. So the limits on freedom of speech and academic freedom, which are permitted by the code, are relevant to anti-Semitic conduct, which may be unlawful as contrary to racial vilification and may otherwise impinge on well-being. It's important to note that those limits while they're applicable to conduct, are also applicable to conduct which, while not anti-Semitic, may have specific adverse impacts on Jewish students and academics. So not all conduct has to be viewed through the prism of whether it is anti-Semitism or not. And one doesn't need to necessarily get into that kind of debate in order to sanction or restrain or constrain conduct which goes to the well-being and of students and staff, and particularly Jewish students and staff. Having said that, I think that is sufficient for the moment to outline the sort of area that of regulation that is open to universities under the model code, and which covers anti-Semitic and non-anti-Semitic conduct, which is nevertheless prejudicial to the well-being and safety of students and staff. There is a question about the definition of anti-Semitism, which is much agitated. There's been a call, for example, for the adoption by universities of the International Holocaust Remembrance Association, which has put out
Alliance.
I'm sorry, yes. Thank you.
No worries.
Which has put out a definition which is expressed as a non-legally binding working definition. When one talks about adoption by universities, you have to ask, what does that mean? Adoption for what purpose? It's plainly not intended as a definition which can be adopted and made a rule of conduct. You have to have something more precise to deal with that. And if you're going to, quote, compel universities to adopt a definition, you've got to ask for what purpose, and how different is that from actually legislating as unlawful conduct which is anti-Semitic pursuant to that definition. And so one has to be very careful about the scope of the definition. That said, there is nothing against the notion of resorting to that definition as a guide for a view which has been expressed and adopted around the world about the sorts of things, and examples are given in the definition of what constitutes Semitic conduct. They're my opening comments, Mr. Chair, and I might just ask the Vice-Chancellor, unless you want to move to questions, I might just ask the Vice-Chancellor to himself make a few comments about UWA specifically.
Please.
Thank you, Chair. Thank you for the opportunity. Chancellor provided a broader framework of our policies, so I'm going to give you a snapshot of situation that we have faced so far. There have been a number of protest meetings and other activities on our campus, and some of those activities or statements made in those events have led some of our students to feel harassed, intimidated, and unsafe. And they have lodged formal complaints with the university using our standard processes. So far, we have received 44 formal complaints. Just to give you a sense of where they came from, 23 of those complaints are related to student guild meetings, and 12 are related to student club activities, 7 are related to teaching and learning activities, and 2 are related to communications. So vast majority of those were related to the student guild meeting, and particularly with respect to the positions taken, statements made during the debate at the special general meeting of the student guild held on October 2nd, 2024. So the express purpose for that special meeting was to express solidarity with Palestine, cutting ties with Israel, and companies involved in weapons production linked to the conflict in Gaza, and the removal of UWA's Chancellor-elect Diane Smith-Gander. So students have found some of the comments to be anti-Semitic, and reported losing friends and feeling unsafe and unable to wear items that represent their Jewish identity. So that's, if you will, a snapshot of the problem that we are facing. So what have we done with it? The policies that the Chancellor has outlined, I'll cite a few of those. Code of Ethics and Code of Conduct, of course, that policy contains UWA's commitment to ensuring an environment free of discrimination, bullying, and harassment. And we also have another accompanying policy, university behavior policy, which adds context to the broader statement in the Code of Ethics and Code of Conduct, and further highlights that racial, ethnic, and religious discrimination and harassment are inappropriate behaviors that are not tolerated at the university. So through the provisions of those two policies, we have initiated 4 disciplinary investigations arising out of the meeting. Based on the preliminary evidence, I have temporarily suspended 2 students pending the outcome of those disciplinary investigations. But the second policy document that has been helpful to us is the one Chancellor has made reference to, our Code for the Protection of Freedom of Speech and Academic Freedom. Without getting into specifics, through the application of the code, we have made determination on number of controversial events. So example number 1, a controversial speaker wanted to speak on our campus. Our committee, advisory committee to the Vice Chancellor, made the determination that although the topic is controversial, but there is legitimate reason for us to allow that to proceed, except that we are not going to allow the speaker to speak during the time they requested, which would have been around noontime, because that was the exam period for our students. So our decision was driven by protecting the psychosocial health of our student body, and we said you can give the speech, but it has to be in the evening. And the speaker and the organizers decided not to take us up on that. Second example, Chair, we also reviewed the screening of a film that can arise controversy and anxiety among some members of our community, but we felt that that screening should proceed, and it proceeded without any incident. Third example, which is on the other side of the, application of the code, we had a controversial speaker before coming to UWA. That speaker spoke in Sydney and Melbourne, so he had advance notice of the nature of his speech, and our committee decided and advised the Vice Chancellor not to allow that event to proceed on our campus, and we denied the request to host the event on our campus, and it was hosted somewhere else. So, conclusion there, maybe I should give you one more example. Chancellor made reference to EWA land bylaws. So that bylaws, section 5.3 reads, no person shall use abusive or insulting language on the land. So that's quite broad. Section 5.4 reads, no person shall do or commit any offensive, indecent, or improper act, nor behave in an offensive, indecent, and improper manner, nor engage in any conduct which is offensive, indecent, or improper on the land. So using the land bylaws, we have issued exclusion orders to 2 individuals related to some of these incidents. So we do have tools that we have been successfully able to use. So far, Mr. Chair, it is our belief that notwithstanding the limitation of those tools, we have been able to use them and try to balance the practice of free speech on our campus while protecting the safety of our students and other staff members. So thank you very much, Mr. Chair, for the opportunity.
Thank you very much, Vice-Chancellor. Forgive me, Vice-Chancellor, I'm just going to start with the Chancellor as I need to pick his brain on a couple of matters. Chancellor, thank you for your time today and for giving of evidence. I mean, one of the things that we are trying to determine is when, when does the right to express oneself end and when should by law or when should by university code people be free from harm or vilification in a way that causes someone harm. What's your thoughts on being able to draw that determination at harm? And it's obviously a higher threshold than just offence, as outlined by the Section 18C in the Racial Vilification Act, but in terms of vilification and where one draws the line, what are your views on that?
I think the issue of harm is an issue, a question begged by John Stuart Mill when he said that all speech should be free except that which causes harm. And the question then begins, well, how do you define harm? And of course, that's very much a range of possibilities. So you can, I suspect you can go first to a core definition for the purposes of this inquiry, that harm is caused by anti-Semitic speech. Okay, and that is speech which targets, the traditional definition of anti-Semitism, which goes back to, I think, about 1879, according to the dictionary, is hostility towards and discrimination against Jewish people. And so the expression of hostility towards Jewish people, which may take many manifestations, including the sorts of examples perhaps that are set out in the definition which I mentioned earlier, that can be readily categorised as a species of harm, not just because of the effect on individuals, but because of its wider societal effects. You know, it unleashes what I call the coiled snake, which we've found being unleashed in recent times. Once you get beyond, then you get into the question of, well, what's anti-Semitic at the boundaries? There may be boundaries where you get people wanting to characterise as anti-Semitic that which can also be characterised as, for example, legitimate criticism of state policies. Yeah. And there are judgment calls there, and sometimes the two things get mixed up. And I think the only way that can be dealt with is to have a rule which allows case-by-case determination, because you'll never nail it all down in words. Yeah. And the more words you write, I've often said this about laws, every new word is an argument waiting to be had. So, like Mozart said to Amadeus, too many notes. I look at the law and I say, too many words. So that's why, for example, if we're defining anti-Semitism, I would prefer a simple, inclusive definition, perhaps derived from the traditional definition, which can then be unpacked, has a clear core meaning, but can be unpacked case by case on individual meanings. Now, the question is, how do you use it? You use it as a code of conduct, of course, and that then attracts sanctions and disciplinary provisions and engages a legal process. And beyond that, of course, there's culture change, there's training, there's education, there's all those sorts of things, which, it doesn't matter how good the rules are, if you don't have the culture right, and then they won't be fully effective. So I'm sorry that there is no clear right answer.
I completely understand. On going back to the definition, is UWA participating in the Group of 8 or the University of Australia process to try and adopt some form of Australian version of what the Special Envoy was calling the Australian version of IRA, in line with what you're saying, Chancellor, about making it simple and user-friendly? Yeah.
Yeah, the Vice-Chancellor has been participating in those meetings, and he can elaborate on that if you want, the GO8 meetings in particular.
Yeah.
So thank you, Chair. We have been participating from get-go with the work of the Special Envoy. Two of my colleagues have participated and contributed to 2 working groups that we have formed as a result of our work with the Envoy. One is dealing with the definition. It's an ongoing work. We are almost at the finishing touch stage. Obviously, people have different views on it. But the second working group is very, very useful and practical. So that's the educational piece that the Chancellor talks about. We have advanced quite a bit thanks to our colleagues at Monash University. I'm pretty sure they have briefed you on that. So Monash University has developed training modules initially for executives or leaders, and we certainly intend to use those on our campus. And there is further work being done by Monash to develop further training modules for people who actually deal with those issues on a day-to-day basis. That's the security staff and folks of that nature. So I'm very pleased with the progress we have made on both counts, but particularly on the training side of it, education side of it.
Do you know the timing, Vice-Chancellor, of when that definition will be announced? They mentioned it sort of last hearing that it was sort of days, not weeks. Do you have any any sense of that?
Senator, I'm not quite sure whether there's any confidentiality requirements, so I'm going to stick my neck out. At our meeting of Group of 8 Vice Chancellor last week, we have agreed to a definition, and the caveat there is we will leave it to each university to use it as they see fit. In our case, our thinking is that we will use it as a guide, along with many other definitions from other universities, including IHRA, by the way. And we have received the correspondence from the envoy. Whether she has given her final blessing on it, I cannot say. So it's almost there.
So the universities have agreed to a definition. That now then is being consulted with the Special Envoy on Antisemitism. She's providing her feedback on it. That's where it is currently. Am I getting that correctly?
Little caveat, Senator, just to make sure that I don't.
Sorry, Vice Chancellor. As much as I one day, maybe sent to the House of Review. I'm a humble member of the House of Representatives, so I'm not a senator. I'm just a member. Forgive me.
I apologize.
Forgive me. Not at all. Not at all.
I apologize for my mistake. So what we have done, this is an important differentiation, Chair.
Yeah.
Vice Chancellors have agreed to a definition. That doesn't necessarily mean that we can bind our universities. So we have to take it to our universities.
Yep.
But I'm confident, speaking on behalf of UWA in the presence of my Chancellor, that UWA will use that guideline, use that definition as a guide. So other universities will have to take it to their system to get it endorsed, approved, whatever. And your last statement is correct. We are waiting to hear from the Special Envoy.
And how?
Chair, can I just
please.
one comment in relation to the way in which a definition of anti-Semitism is used, insofar as it's put into a code of conduct or a disciplinary rule, it should be addressing not just cases of harm to individuals, that is anti-Semitic speech or conduct directed against particular members of students or staff, but I think more generally as a societal evil, so that one can constrain freedom of speech that is anti-Semitic regardless of whether it is directed against a particular individual.
So in saying that, Chancellor, the university, or if someone brings a complaint against a lecturer or a student or someone who's in a public place, and even though it's not particularly targeted at one individual per se, if someone says something that is contrary to the definition, that could be used in a complaint to the university in a legitimate process set out by the university.
Yeah, I don't think we can tolerate anti-Semitic speech in any form.
That's excellent. Are you able to share the definition with the committee, Vice Chancellor, even if it's by on notice? I mean, I'm expecting to hear from the Group of 8, but we were unaware of the meeting that had already occurred, so we're very appreciative of the honest and transparent way in which you've engaged with the committee. Is that something that you'd be able to share with the committee, or yeah?
Senator,
Chair.
Sorry, Chair.
That's all right.
I've
been called, Vice Chancellor, trust me, I've been called worse. Don't worry. Not that much worse, but a little bit worse.
I'm in the same place, Chair. It's a moving target, Chair. So it would be probably better for Group of 8 to provide you with the latest version in case I may not have it.
Okay. So it hasn't yet been agreed to? Or it has?
To the best of my knowledge, it has been agreed to, but I just don't want to commit Group of 8 by sharing the latest version that I have in my hands.
Okay, no worries. We'll await that. I'll hand over to the Deputy Chair, and if there's time, I'll come back to questions.
Thank you, Chair. Mr. French, I'm sure you've been keeping a close eye on the uses of your model code and I was hoping I could draw you out a bit on that to see, if you could maybe provide some comments to us on how you think that has been, how the implementation of that code has been handled by Australian universities, and particularly if you've got any comments on how that code has been leaned on or utilised by the universities in relation to dealing with, the spate of anti-Semitism that we've seen over the last year and a bit.
Yeah. First of all, at a general level, the adoption and use of the code was reviewed by Sally Walker in a report that she did for the government a couple of years back, I think, and I think Alan Tudge might have been the minister at the time, and there was a subsequent requirement suggested for universities to include a template in their annual report setting out how they had responded to the code. As I said before, the code does not set out a code of conduct itself. What it sets out is the categories of constraint that can legitimately be imposed on freedom of speech and academic freedom. To the extent that I can't comment on the extent to which it has been relied upon by universities in framing their codes of conduct so far as they relate to anti-Semitic conduct. The impression I get, and I'm sorry, this is no more than an impression, you need to get more concrete evidence, is that they are relying upon existing codes of conduct which target things like, racial vilification and discriminatory and insulting and intimidating and harassing and threatening conduct and so forth, all of which can be accommodated within the model code on freedom of speech and academic freedom.
Thank you, Mr. French.
So to what extent it's had an influence, I can't say.
No, that's all right. Vice-Chancellor, the University of WA, did you have an encampment in the course of this year?
No, we didn't.
Right.
If I may add, further to our discussion on land bylaws and the Chancellor's statements, we are not going to allow an encampment using the provisions of our code, but more importantly, provisions of our land bylaws.
Okay. Well, that seems to be a different experience than most of the universities had across Australia. Was there any risk of one? Was there any action taken by the university to avoid that outcome? Were you proactive in informing students that this would not be tolerated?
Thank you, Vice Chair. Yes, we have maintained a very close collaborative relationship with our student guild. We have supported them along the way, and through those mechanisms, we have made it abundantly clear that while we protect free speech, if people want to come and speak, we have processes to evaluate them. If they want to demonstrate, as they do in front of my office and others, they're welcome to, but we are not going to allow any structure to be put on a campus on various grounds, including health and safety grounds.
Absolutely. I think that's a very good approach. You mentioned the two suspensions that have been, it was temporary suspensions, wasn't it, that's been issued to students at your university. Were these for individual offences, or were they were these repeat offenders?
I cannot say whether they're repeat offenders, but these are for individual offences. Mm-hmm. We have evidence as to the statements they have made, and based on those evidence, as I said, I have temporarily suspended them. Investigation is underway. We have also taken steps in raising our concern with our student guild with respect to the activities of a couple of clubs associated with it. So we haven't made any determination as yet whether they have collectively violated our policies or not, but certainly you have served notice that some of the complaints that we have received are against two particular clubs.
And so, just so I can get this correct, the there hasn't actually been a hearing into these, or the process hasn't been concluded for these students. They've just been issued with a temporary suspension while that process runs its course.
Process is underway,
Right.
Deputy Chair, but it hasn't reached a conclusion as yet.
Okay. And how long after, we're just trying to, just for your context, I'm trying to get a sense as to the timeframes and the swiftness of each, not necessarily trying to create a chart as to, whose issues the swiftest justice across the university campuses, but what is, from the point where the incident occurred or incidents occurred, how quickly was that suspension issued from that point, and how long would you anticipate from that point to the conclusion of the process would be?
So the first question, I don't have the specific dates. I think within a week.
Wow.
The complaint was lodged the day after the event, and we immediately started our investigation. And based on our preliminary findings, with less than a week actually, I determined that it was appropriate for me to suspend 2 students temporarily. The process, how long it will take, I hope we can conclude it sooner than necessary, but it depends on how cooperative those students who are under temporary suspension orders are.
That seems very quick and very appropriate. I think that's a good example for us to look at. Finally, Vice Chancellor, has there been any complaints made in relation to any of the university staff when it comes to, in relation to anti-Semitic activity or behaviour?
To the best of my knowledge, there have been complaints, but I'm not quite sure that they are directly anti-Semitic. One specific complaint that came through informal channel, I don't have the specifics as yet. I was meeting with 3 community members, 2 of whom have their children studying at EWA. So one brought to my attention that in a classroom setting, a professor, still unnamed, unidentified, allowed somebody to make statements that are anti, if you will, state of Israel. So our position is classrooms cannot be used to make any statements of any kind. So we are going to try to get more information on those sort of things. And then we are going to advise our heads of school that they should remind our staff that classroom time is for teaching purposes only and cannot be used to make any statements one way or the other.
And could I just add, this is not just seen through the prism of what's anti-Semitic and what's not. It covers a broader range. And as I said before in opening, our responses to or constraints on expressive conduct don't necessarily all have to go through the channel of is it anti-Semitic or is it not. There's simply no freedom to start making statements at the beginning of a class.
Yes. Thank you very much. That's all from me, Chair.
Ms. Bellier, and then I've got a question as well. But Ms. Bellier, you have been waiting patiently, so over to you.
Thank you, Chair, and thank you to the Chancellor and Vice-Chancellor for your overview of all the work you've been doing. I suppose it's a bigger picture question around what else would you as a university need or require from us as government or from law enforcement to help you manage these events? What's missing?
You want me to go, Chancellor?
Yes, sir.
Well, this may be asking for too much. The case I cited where we had to stop a speaker from speaking. So when we are doing our research, it is very well known that he was a controversial speaker. He is on the record of, making statements celebrating the October 7 massacre in Israel. So that was the basis for us to stop him from speaking. So the question arises, why would we allow such a speaker from overseas country to come here? And once he landed here, one once we saw there was ample evidence that he was causing, if you will, significant, social unrest in Sydney and Melbourne, why wouldn't we quickly deport him? So the last stop in his journey was University of Queensland. We got only 24 hours notice because of the way we book our rooms. We actually learned from the newspaper that he's on 21-hour campus. UQ had a bit more time to deal with him. They also excluded him from the campus. So, we'd like our governments to take a more proactive action on that. And then finally, our land bylaws allow us to remove people, but physically we can't do that. We don't have the police force. So to enforce our bylaws, we will need help from law enforcement agencies. And any strengthening of hate law, I'm not a lawyer, so the Chancellor would have probably a more nuanced view on it, but any more legislative measures that you can take would certainly strengthen our hands and give us more tools to deal with these sort of issues.
Maybe I can supplement that by saying that when it comes to operationalising constraints based on anti-Semitism, it would help if we could have a consensus around the nation of what constitutes the kind of anti-Semitism that we can put into a rule of conduct, perhaps a higher education standard, a specific standard directed against anti-Semitism, or even a law which is a specific application of Section 18C. You always have to be careful, of course, with those definitions. It's a bit of a minefield as to if it's fuzzy at the edges, then you start running into the area of implied freedom of political communication and so forth. But I do think that a rigorous look at an operationalisable definition by government would assist.
Thank you. That was one of my other questions based on all the presentations today was, how important is a definition or definitions? And then that informs a code and, an understanding of what is harmful behaviour that requires different approaches. So thank you very much.
Thanks, Jodie. Can I just ask a couple of last questions to the Chancellor? Is there any possible constitutional concerns if universities were required to adopt certain policies to address anti-Semitism?
Well, it depends what you mean by adopt. Sorry to be a lawyer.
No. I feel you're well practiced in that, Chancellor. Specifically around, either the policies around adoption around definitions, adoption around codes of conduct, adoption around, even transparency measures. Is there any constitutional concerns that you would have if we were to enforce universities adopting those policies?
Well, there's always a question of the scope of extent of Commonwealth power in higher education. I know that appears to be the only game in town, but they are all state institutions, and there are certain limits as to what you can do with state institutions. But beyond that, the fundamental question has to be, the anterior question has to be, when you say adopt, what do you mean? Do you mean that you've got to, that nobody else can challenge that this is the received definition of anti-Semitism for all purposes within the university, can't be open to discussion, can't be open to debate, can't be challenged? So I think that the use of the term adopt is pretty loose with respect. Right. And that what we ought to be talking about is, if there is to be a rule, an operationalisable, I'm sorry for the word, rule against anti-Semitism, which universities are required to incorporate into their codes of conduct, then you need a definition which is workable in a legal sense, because it's going to involve sanctions against people. It's going to be subject to legal challenge. And if it's too fuzzy, you run into the implied freedom problem.
Right.
The easier thing is just to make a law which covers anti-Semitism right across the board. And then it applies to universities and everybody else in the community.
And that there's no constitutional questions you would have around the federal Parliament writing that law?
Well, it could be a specific application of the Convention for the Elimination of All Forms of Racial Discrimination. Having said that, I did say in advocacy of the voice that there is no constitutional problem, but others disagreed.
Well, as you said, one word equals many arguments, but yes. I really appreciate that. My other question, and then I'll hand over to Senator O'Sullivan as well, is do you think that if there was a Federal Human Rights Act and universities were considered a public authority, that could assist in balancing the competing rights in this space?
Well, if it were on the model of Victoria and Queensland and the ACT, it would mean that the human rights enshrined in the Act would be mandatory relevant considerations for the exercise of any statutory powers by the university, which would include, I guess, disciplinary powers in relation to conduct. I presume that's what you have in mind when you talk about a Human Rights Act, rather than one which.
And also the sort of intersection between the rights outlined in your code of the rights to freedom of speech and the right to be free from discrimination or vilification.
Yeah, well, I mean, the anti-Semitism itself is a breach of a bunch of human rights under the ICCPR, and I think your committee itself, of course, has to look at anti-Semitism within the prism of the human rights set out in the Parliamentary Scrutiny of Human Rights legislation. All I can say is that the introduction of such legislation, making it mandatory for universities to have regard to the human rights in relation to the exercise of their statutory powers, perhaps you could extend it in the exercise of the formulation of codes and so forth and policies. I don't personally see a huge problem with that kind of imposition from a constitutional point of view, but you've got me on the fly, and you might get a different opinion from others.
Well, I guess all I would say is, and absolutely, if there's nothing else that comes to mind, then no problems. But if there is any other further thoughts on that, or anything that may be assisting the committee on balancing those rights, we would, of course, be very welcome of any further thoughts you have at any point.
Yeah, I just think you need to unpack the word adopt.
Yeah, okay.
And think about that bit.
No worries. I'll hand over to Senator O'Sullivan.
Thank you very much. Just one question from me, dialing in also from Western Australia. I wanted to thank you. It's been an excellent discussion, so I really do appreciate what's been discussed already. But I just had one further question for you, Chancellor. The Special Envoy has called for judicial inquiry into anti-Semitism. Do you have a view on this, and particularly keen to understand if you support that call?
Look, I don't have a strong view on it one way or the other. There has been a plethora of, we've had the Legal and Constitutional Affairs Committee. We've got this committee, which is really focusing on the issue in a fairly, and this committee has all sorts of powers, of course. The question you have to ask is what additional utility there would be in a judicial inquiry. I guess it would get more granular. It would spend more time looking at particular cases and then develop a big picture out of that. And the question is whether that is necessary or likely to accelerate the kind of responses that seem to be required to deal with this phenomenon. And that's a matter of judgment, really, for the politicians. How fast can governments and universities act in response to the situation, as well as general society, and how much more effective would their reactions be in light of a judicial commission of inquiry? The problem is they do have an infrastructure around them. They do have a process. You have counsel assisting. You have all kinds of, and the process tends to extend over quite a period of time. I favour considered but reasonably prompt action. But I'm not against a judicial inquiry if people think that would be useful.
Thank you. Thanks for that. Thanks, Chair.
Thank you, Senator. Well, I want to thank you both for appearing before the committee and the giving of evidence and of your time today. I'm not sure what time it is in WA. I can never keep track of that. I'm sure it's yesterday sometime or something like that.
It's 10 to 9.
Right. But no, thank you very much. We really do appreciate it. And the committee does request that answers to questions taken on notice are provided to the committee secretariat by close of business 13 January 2020.